You need to talk to me about my animals. I asked you a question. Are you going to talk to me about my animal?
I'm going to talk to you about that misdemeanor case in just a minute. I have to make a few notes in this
All
file,
right.
and then I'm going to talk to you about that other file. So yes, ma'am, I will. Just hang on a second.
Thank you.
Mr. Matisse, do you waive the reading in the circuit court arraignment?
He fought with multiple officers in the hospital. He also attempted to strangle the hospital security staff. I believe he is a danger to the community and a danger to himself. And I believe bond is correct at what it is set right now.
All right.
I'm honestly disappointed by the courts, the counting, and everything else.
This is the state of Michigan versus Chelsea Brink, file 25-44174-FY, set for a status review. Mr. Brown, I believe this is your matter.
It is, Your Honor.
We have a resolution.
We have not reached a resolution yet. However, I believe that we are willing to request a waiver and have the matter bound up to circuit court. I have gone over potential plea offers with Ms. Brink, and she is aware that district court cannot handle those, so it would need to go up to circuit court. So we would like to enter that waiver today, and I would also like to address bond before the court signs that as an order.
I would be happy to let you do that. Let me speak to Ms. Brink about the waiver process. Ms. Brink, you've heard what your lawyer has said. Is that what you want to do?
I guess so.
Moving your case up to the circuit court is where the case would ultimately be resolved, as this is a felony matter. It can't be resolved in the district court. Before it goes up to circuit court, you have the right to have a hearing called a preliminary examination. You also have the right to waive or give up that hearing if you wish, and that's what your attorney is recommending. The hearing at preliminary examination is simply a chance for the prosecutor to bring in a small amount of evidence called probable cause that you've committed these crimes that have been charged. It is not, let me repeat that, it is not a determination of guilt or innocence. It's simply a check to make sure that there is some evidence to proceed with the case. Do you understand all of that so far?
Yes, sir.
Your attorney has said that he is continuing to negotiate with the prosecutor, and he would like to move the case up to circuit court to try to resolve it up there. Is that okay with you?
Yes, sir.
Has anybody promised you anything or threatened you in any way to get you to do that?
No, sir.
You're doing this of your own free choice and free will?
Yes, sir.
All right. In a minute, I'm going to ask you for permission. Well, I'll just do it now. There's a form that has to be signed in order for this to occur. Do I have your permission to sign your name to that form?
Yes, sir.
All right, I'll do that now.
Mine as well, Judge.
Thank you.
It might as well, Your Honor.
Thank you. As to your motion on bond, Mr. Brown, what would you like me to hear?
Your Honor, I would just ask the court to, I'm not even sure what her current bond is or if it was revoked. It's been quite a while. As the court is aware, she was sent to the Forensic Center for competency evaluation, which has come back that she is now competent. She has been sitting a substantial amount of time in jail on these charges, relatively low-level felonies, as well as sitting at the Forensic Center, which isn't jail. However, it does restrict her freedom. So I would ask the court to consider giving her a PR bond.
Please, Your Honor.
I'll hear from you in just a minute, Ms. Brink. Thank you very much.
So right away, this one's about whether she can stay out.
Court file indicates that I believe the current amount is $10,000 cash or surety, with conditions including the normal reporting, no substance abuse, participate in community mental health and follow the recommendations, no contact with Lisa's Tavern. Ms. Brucker, do you have a response or comment?
Just that I recall in one of Miss Brink's files, I don't remember if it's this one or one of the other ones that's still outstanding, that in at least one of them, I recall she didn't have anywhere else to go. She was staying in the lobby of the sheriff's office, and there were some difficulties getting her to leave. So I'm not sure that she has an address to go to. And obviously, if she's following her treatment, I'd ask the court to continue ordering that she follow her treatment if the court does reduce her bond. But I think one of the concerns is our ability to get mail to her and communication to her to make sure she has a safe place to be.
And Your
Ms.
Honor,
Brink, you had
go
ahead,
she
Mr.
will
Brown.
address that. It is my understanding she is following her treatment. In speaking with her, and the court could probably see her demeanor is much better than it has been in the past. She is taking her medications the way that she should, but I will let her speak as to any kind of residence.
All right, Ms. Brink, you wanted to say something?
Yes, sir. Just that I would appreciate and love a PR bond, but as far as residence goes, my parents are kind of almost expecting me or able to give me a ride to the homeless shelter in Traverse City today and or tomorrow. My dad works he works 2 part-time jobs, and he's able to give me a ride over there, and that would be the most stable housing that I have had in a long time. And just that I'd like to get over there before all the spots fill up.
If you're in Traverse City, how are you going to get back to the? We can do a lot of this by Zoom.
Right.
You may have to get back in person to the court system here in Gaylord in the future. How are you going to be able to do that?
Well, I guess I'll have to address that. I was thinking I could go to the Traverse City courthouse and do it that way. And if there's more jail time that I have to serve, then I'll just report to the Traverse City jail.
It's not that easy. Each court kind of has their own way of doing things, and I can't sentence you to. I'm not saying that I'm going to, but I can't put you in jail in Traverse like I can here. I don't control that jail over there like I have the ability to put people in the jail here in Otsego County. So, but you're right. We can walk over that bridge when we get to it. All right, Mr. Brown, any last comments?
No, Your Honor, thank you.
Judge, I guess
Brink, go ahead.
my last comment was just going to be, obviously Miss Brink appears to be doing a little bit better, and I hope if she was to go over there, she has a way to connect with her treatment providers. I don't know if they're in Otsego County.
Yes.
And stay on the path that she is. So that would just be my other concern.
Thank you, Ms. Brink.
No, I have full intentions of contacting CMH.
Are you currently on a regimen of medication?
Yes, sir.
Do you have the ability to take care of that on your own if you're outside the jail?
Yes, sir.
What would be how often would you be in contact with your community mental health people?
Well, initially, they set a schedule. So I would have to contact them. They would do an intake, and then they would set a schedule. But more than likely, it'll be at minimum once a month. But maximum would be once a week.
All right. Your bond right now requires you to follow all of those requirements. So if
Yes,
you're going to
sir.
be released, you would need to continue to follow up with your medication and your appointments with community mental health and any other doctors that they recommend that you be in contact with. Are you going to be able to do that?
Yes, sir. They have free busing in Traverse City. Plus, I have intention on getting a job, and the job opportunity is much better over there, obviously, because it's a bigger city. But the free busing and CMH will come to me too.
All right.
Sounds hopeful, but one bad move and she's right back.
Well, I want to encourage you because it appears to me today that you are doing much better than when I've seen you in the past. And I want to encourage you to continue to do that, because if you don't, it deteriorates rapidly and then you're right back into the jail system and things don't go very well at that point. So I want you to be able to stay out, but you've got to stay on your medications and keep in contact with community mental health. Or the only other thing that I can do is bring you back here and put you in the jail here. And I don't want to have to do that.
Your
Right.
Honor,
All right. So I am going to change your bond.
Your Honor, I think She may have something on her probation violation as far as a bond as well.
On a misdemeanor matter?
She is still on
Not on this file?
probation and she has a violation. I didn't realize she was back from the treatment center. So it was
All
set
right.
out for a further date. I can bring her file in if you'd like.
No, I think what I'm going to do in that file is do a bond consistent with, I'll grant her a PR bond in both files.
Okay.
That way we can take care of it when it's already scheduled, but it won't impede her ability to get out. So I'm going to change your bond. The only thing I'm going to change on your bond, Ms. Brink, is I'm going to make it a PR bond. It's still going to stay at $10,000. The only thing that's going to change is going to go from cash surety to 10%, excuse me, to PR, meaning that you can be released today once the paperwork gets to the jail. But
Okay.
you still have all of the same requirements, that you not leave the state, not commit any crime, notify the court of your change of address, not use alcohol or marijuana or controlled substances, participate in a substance abuse testing program. That would be through community corrections, not purchase or possess a firearm or a weapon, stay away from Lisa's Tavern, and that you follow all of your recommendations for community mental health. You understand all of that?
Yes, sir. Thank you. I
All right, so
appreciate you.
we will process that paperwork as quickly as we can and get it over to the jail. Ms. Hill, if you would take care of the probation violation side of that, I would appreciate it. And then you are bound over to circuit court to stand trial or to resolve the case up in the circuit court, as we previously talked about. That's all for today. Thank you, Ms. Brink, and good luck to you.
Thank you, sir.
Next case is the State of Michigan versus Timothy Wadesky, file 26-44590-FY, set for a status review. I see Mr. Wadesky at the county jail.
Thank you, Your Honor. Richard Trush appearing on behalf of Mr. Wadesky.
Thank you. I believe you're aware, Mr. Trush, but we just arraigned Mr. Wadesky on other or new charges, I believe, yesterday. And I don't know where the outcome of that is yet. I assume because it was just yesterday, it's not been set for anything yet. But I wanted you to be aware of that because I believe that you're going to be appointed on that matter as well. Given that new information, what do you want to do today?
Thank you, Your Honor. I was aware and did receive the appointment for that yesterday. Given that information, and I've discussed this with Mr. Wadesky up at the jail today, we're going to waive the 21-day rule and ask the court to line up those court dates so that we can try to resolve all of this together. And then we would like to address bond to the court as well.
Be happy to do that in just a second. Mr. Wadesky, you understand that you have the right to have a preliminary examination within a short period of time called 21 days. That's why they call it the 21-day rule. But you also have the right, as your attorney is suggesting, to bump that back, in this case, in order to line up both of your cases at the same time so he can resolve both of them together. Is that okay with you?
Yes, Your Honor.
Has anybody promised you anything or threatened you in any way to get you to do that?
No, Your Honor.
All right, I will indicate for today's purposes that you've waived the 21-day rule. I've made a note in the court file that we combine this for scheduling purposes with the other felony matters already in the court. Mr. Trush, you had an issue as to bond?
Yes, Your Honor. I understand that Mr. Wadesky was participating in the drug court prior to these events. I'm to understand from talking to Mr. Wadesky, and I don't have discovery on the second file yet, but it sounds as though they are connected or related events. He reports to me that he was having some mental health struggles. He says he was ultimately, after the event, transported to a psych ward for a period of time. I would ask the court to consider reducing the bond so that he could be released and could return to reporting with the drug court. I did speak to Mr. Hamlin about that as well. Mr. Hamlin indicated that if he was released and was reporting, he would be basically back to like phase one, reporting every day, which we would be agreeable to if the court were to consider reducing that. Would also indicate I did have some conversation with Mr. Dick about this as well, as he is the drug court attorney, and I suspect is going to have essentially the sanction part of this as well.
All right, Mr. Hamlin, any comments that you wish to make at this point? Then I'll get to Mr. Wadesky in just a minute.
5 pending sanctions? Yeah, that's already ugly.
I think it'd be appropriate to just advise the court right now that Mr. Wadesky's been in the program for 553 days. He does have 5 pending sanctions on the drug court side. That's all I can really contribute to at the moment.
All right, thank you. Mr. Wadesky, is there anything else that you want me to be aware of?
I just would really like to get back to putting the next right foot forward and getting back to drug court, continue drug testing, seeing Rosario as and Kim Murphy and doing my group therapy, as those have both been very helpful for me. I even admit I said earlier this week or late last week that, you know, I would like to see Luke 5 days a week if I could get released, you know, from jail as well.
Thank you, Mr. Wadesky. Mr. Truce, any other comments that you wish to make, or before I get to Ms. Bruker?
No, Your Honor. I think the court has probably more information at this particular stage than I do, which isn't my favorite position to be in, but.
Ms. Bruker, any comments that you wish to make?
Just that I don't think any circumstances have changed from the other day when he was arraigned and bond was set at what it was. It will have to be a cash or surety bond because he does have at least 2 felony convictions within the last 5 years. I would just note that the 2 felony convictions are resisting and obstructing a police officer.
And there goes any shot at a lighter bond.
He has multiple new counts of resisting and obstructing a police officer. He fought with multiple officers in the hospital. He also attempted to strangle the hospital security staff. I believe he is a danger to the community and a danger to himself. And I believe bond is correct at what it is set right now.
Thank you. And just for Mr. Truce's information, because I know that he is speaking with less than full information, the 2 different files are out of the same set of circumstances where he fought at the hospital with both hospital personnel, which is 1 file, and then police officers on the way to the jail or getting ready to go to the jail, which is the other file. They were simply brought a number of days apart because of the separate nature of the victims in it, but not because of the circumstances of the event. I believe that the 1 file has involving the assault with intent to do great bodily harm or strangulation is set at $50,000 cash or surety. And then the other file is set at, I believe, $5,000. And I told Mr. Wadesky at the time that I said it, if it was a standalone file, it would be much higher than that. But because I was aware of the previous case, I set it that second file at a much lower amount. And I still believe that that is proper. Between the 2, there's $55,000 in cash or surety. And given his number of convictions in 2025 for assault on police officers, and I believe that he had other, but I can't remember them off the top of my head. But I do believe that he is a danger to himself and to the drug court participants at this point. This is not the first time we've been through with Mr. Wadesky within the last 12 months with a mental health issue that involved some serious allegations of behavior that could be violent and led him to be hospitalized. And this is not the first time that he's fought with people as a result of some of those behaviors. So I'm not going to risk not only his health, but the health of Mr. Hamlin and or the drug court peers that he has there and release him on a lesser bond. I think the bond is set at a reasonable amount in both cases combined, and therefore I'm going to deny the request for a reduction in bond.
Understood, Your Honor. Thank you.
All right, the last case for this afternoon's docket is State of Michigan versus Soraya Burns. File 26-44577-SM set for a status conference. And then we also have a second file with Ms. Burns 26-44575-FY set for status review. Mr. Matisse, your appearance?
Gabriel Matisse on behalf of Sarah Burns, who I
have my
there,
phone function.
that seems to be
Ms.
her
Burns,
judge.
can I get your, I'm sorry, Ms. Burns, can I get you to turn on your video, please?
No, I'm trying to. I really don't know. What?
I don't know what I did.
Thank you. Tempting. I'm trying to get it on right now, sir. I'm an abutist. When it comes to anything out here, it's
There's usually a button that has a video, looks like a video camera on it.
trying to. It's bad reception. Fix it.
I'm trying.
I know.
There it goes. Okay.
Can you see me?
Yes.
I can see you and I can hear you now. Thank you very much. Glad that you're
Okay,
able to do this.
I'm trying. I mean, my environment out here, it's very bad perception.
All right. Well, we're good for right now. So, Mr. Matisse, is there a resolution of these matters?
Your Honor, I've spoken with the prosecutor and with Ms. Burns about this. With regards to the felony file, we would like to waive the preliminary examination. If the prosecutor could please put the record on, or offer on the record, we'd like to also waive the prelim in order to preserve the record and continue on with further negotiations in the felony case.
Highest probation you can give me. It's not gonna do anything for my children or myself.
Okay, Ms. Burns,
you're
hang on a second.
literally going to
Ms. Burns,
Yes, sir.
there's a process that we have to go through before I'm going to give you a chance to speak. I will give you a chance to speak in just a minute, but Mr. Matisse has asked the prosecutor to do a couple of things, give me information, and then once all that's put together, then I'm going to come to you. So if you just be patient with me, let me get through this part of it, and we'll talk to you in just a minute. So, Ms. Brucker, as to the offer on the felony matter.
Your Honor, in the felony,
I can do that.
The felony is, the offer is for her to plead to counts 2 and 3, and those are 2 counts of resisting and obstructing an officer. And in exchange, we dismiss counts 1 and 4.
Thank you, Your Honor. At this time, we'd like to plead not guilty, waive the prelim, and bind over, if that's okay with the court.
Absolutely. All right, Ms. Burns, the offer in the felony file has been stated on the record, and because it involves felony matters, I can't hear that case. I'm limited in my jurisdiction to what I can do. So the request from your attorney is to move the case up to the circuit court where it can be resolved up there. Is that okay with you? All right.
That's all right with me, please. You can give me the highest probation or anything.
Well,
I've never been in trouble in my life.
Charges. Okay, so I just want to make sure that you understand the case that's going to move up to circuit court. You have the right to have a hearing on. That's called a preliminary examination. That's where the prosecutor would bring in a small amount of evidence that you've committed the crime that you're charged with. However, you can also give up. You can give up that hearing and move it to circuit court. Is that what you want to do?
My attorney will speak for me.
That's what your attorney is requesting. So is that what you want to do?
No, if that's what he speaks for me, then I talked to Gabriel earlier. Everything, if that's what he speaks for me, he speaks for me. I have no adherence to anything, and I literally have never hurt anyone, harmed anyone, or literally dealt with anything like this in my life.
All right. So let me ask Ms. Burns, let me ask a specific question to try to help the situation. The request to move up to circuit court requires that I find that you're doing this voluntarily. Nobody's forcing you to do it. Is that true?
If Gabriel would see that as the better choice, then I trust him at this point in time.
I'm glad to hear that, but that's not what the question is. The question is anybody forcing you to do that?
Oh.
All right.
What? No, nobody. Nothing.
All right, and
no discretion.
all right.
I'm I'm honestly disappointed by the courts, the counting, and everything else. I really am.
All right. So in the felony case, that's going to go up to the circuit court. There's a form that needs to be filed to do that. Do I have your permission to sign your name to that form to allow that to occur?
It'd be all right with that hassling. That'd be all right.
All right. I'm going to sign your name right now so we can get that out of the way.
Disappointed.
Mr. Matisse, do I have your permission?
You do, Your Honor. Thank you.
And my permission as well, Your Honor.
Thank you.
Thank you, all of you. Thank you. I really appreciate that. That's all. Gabriel will speak when he wants to. I'm not going to talk to you any further.
Well, I have one more file. I have one more file to talk about, Ms. Burns. So if you just wait just a minute, we'll get to that shortly.
All right. You're going to talk to me about my animals? I asked you a question. Are you going to talk to me about my animals?
I'm going to talk to you about that misdemeanor case in just a minute. I have to make a few notes in this file, and then I'm going to talk to you about that other file. So yes, ma'am, I will. Just hang on a second.
Thank you.
Mr. Matisse, do you waive the reading in the circuit court arraignment?
I do.
I have physical evidence that I was
Okay,
medically.
Ms. Burns, you just got to wait a minute. As soon as I'm done with this case, this file, I'll turn my attention to your other case and I'll give you a chance to speak. So just give me a minute.
Okay, I can deal with that.
Thank you.
You're welcome.
We'll enter a not guilty plea on her behalf and continue to bond in that circuit court matter. All right, Mr. Matisse, as to the misdemeanor case involving the animals, is there a resolution in that matter?
Judge, there is not a resolution yet, and there's a reason for that. I'm going to meet with my client tomorrow. Ms. Burns and I are going to meet up in person, and I'm going to get some documentation from her that I think I need to get to the prosecutor to show that she was going through some medical trauma at the time, and I'd like the prosecutor to have that for their consideration. So we're going to sit down and have a meeting. I believe we got arraigned on this one last week. Is there any way we can have another status review for the new misdemeanor file, Judge?
Absolutely.
Nobody's given me documentation or anything. I
think your attorney is going to be able to assist you with that, Ms. Burns. So when you meet with him, he should have some paperwork from the prosecutor's office that he should be able to share with you. And then he's going to get some paperwork from you to share with the prosecutor. And in that way, try to resolve this matter. So, all right. Let me give you a date when we're going to come back to court after all that's occurred.
All right. Thank you. Thank you.
June 17th, a Wednesday at 10 a.m. Does anybody have a conflict with that?
No, Judge.
No, Your Honor.
All right, 6/17 at 10 a.m. We'll do another Zoom hearing just like this, Ms. Burns. And in the meantime, you're going to have a chance to meet with your attorney and discuss this case in full with him to help him be able to better negotiate with the prosecutor's office. All right?
Mm-hmm.
I didn't really do anything wrong.
Well, that's what your attorney is going to reflect with the prosecutor's office. He's going to talk to them about that. So I think that's all we can do for today.
Essling, thank you.
You're very welcome. Have a good day.
You
that's
as well.
Thank you, Your Honor.
Court will be in recess. Thank you all very much. Appreciate your time.